some amendment, some regulation can be inserted, and it may be helpful for an IRP or RP to complete the proceedings within a timeline. Would like to share the screen with regards to Mediation Act 2023. Would like to discuss on, would like to deliberate upon the same. And after its completion, I would like to share my views. I would like to express my views that how the mediation can be helpful in CIRP process. Yes, sir. And will be more happy to have your views on the subject. As such, there is humble request that whatever may be the point of discussion, we should stop at that moment itself. We can have a discussion, we can interact on the subject, and thereupon we can move forward. Further, the suggestions from your end will be invited, that because whatever is going to be the discussion, that how the mediation can play a big role in CIRP, there I will be having your viewpoints on the same, which may differ, which may run parallelly. But yes, first we will be going through the Mediation Act, and immediately thereafter, the discussion will be taken place that where the mediation can be placed in this process of CIRP on both pre-CIRP and post-CIRP stage. Is my screen visible?
Yes, sir, very much.
Thank you. So the purpose of sharing the screen is a very recent enactment. A month back, got the presidential consent on 15th September 2023. That's now been the act. When you see the objective of this particular act, you'll find this is an act to promote and facilitate mediation. I believe this because in CIRP, the dispute is just a dispute of their own interest. Whosoever may be the applicant, whether it is a bank or a financial institution or just a service provided under Section 9, this is an option which can be opted before directly moving an application before the NCLT. We will be coming to that. This is an act to promote and facilitate mediation, especially institutional mediation. And in this particular Mediation Act 2023, there will be a position given to the Mediation Council of India. And within that Mediation Council of India, there will be a mediation service provider, and there will be a mediation institutes. So there can be NCLT mediation cell, or there can be NCLT mediation center, which can be proposed. So this is an act to promote and facilitate mediation, especially institutional mediation for resolution of disputes. When we connect with the IBC, default leads to dispute, and dispute is just for the sake of the amount of debt. Commercial or otherwise, in IBC, we have all the disputes are the commercial in nature. Enforce mediation settlement agreement. This is what we are going to discuss upon. If the settlement is arrived between the parties, there is nothing like arbitration award in mediation, but there is an agreement which is going to be executed by the parties, and that is going to be countersigned by the mediator. Provide for a body of registration of mediator to encourage community mediation and to make online mediation as acceptable and cost-effective process for matter connected therewith. So basically, this is the aim of mediation. Now, when we see that what exactly or what is the meaning of mediation in this particular act and what role mediator is going to play, this is also provided in the definition part itself, and this is clause H. When we talk about the mediation is nothing but a party's attempts to reach an amicable settlement. We will be emphasizing upon the mandatory pre-mediation in CIRP, wherein the parties attempt to reach an amicable settlement of their dispute with the assistance of third person, referred to as an arbitrator, who does not have the authority to impose a settlement upon the parties to the dispute. So basically, there will be no binding obligation on the part of the mediator that settlement has to be arrived. He will be just a person who will be placing the thought process or viewpoint of one party before the other party, and will be placing that all possible means that through which the amicable resolution to any dispute can be derived. So when we talk about the mediation, mediation is nothing but it is an attempt. So this is first of all a voluntary act, wherein in the IBC we are going to talk about how it should be considered as a mandatory provision before invoking an application under section 7 or 9, which is there in the Commercial Court Act. So before you file a suit, it is mandatory upon the parties to first opt for a mediation. Suppose if mediation fails, then only the matter will be referred as a suit. So where a party attempts to reach an amicable settlement of their dispute with the assistance of third person will be referred as a mediator who do not have any authority to impose a settlement upon the parties to the dispute. Now, there is a role also which is provided in section 12 of this particular act, or a 16. This is the role of mediator, which is very important. Rather, section 16, rather 12, it's section 16, which talks about a mediator shall attempt to facilitate voluntary resolution of dispute. Shall attempt to facilitate voluntary resolution of the dispute by the parties concerned, communicate the views of each party to the other to the extent agreed by them. So whatever may be the points agreed upon by both the parties, through that particular point which has been agreed upon by the parties, the settlement will be derived. Assist them in identifying the issues, advancing better understanding, clarifying priorities, exploring areas of settlement, generating opinion in an attempt to resolve the dispute expeditiously, emphasizing that it is the responsibility of party to take reason regarding their claim. So basically, no dispute is going to be adjudicated upon by the mediator. Mediator is just going to be a facilitator through which the settlement can be proposed, through which the settlement can be tried upon. One more important aspect, because this will not consume time, when you see the time limit for completion of mediation, but we will also see that when it will be commenced. First of all, it is provided that notwithstanding anything contained in any other law for the timing in force, mediation under this act shall be completed within a period of 120 days from the date fixed for the first appearance before the mediator. 120 days is nothing. In section 7 or section 9 application, 120 days, we have seen that not even pleadings get completed. Not even pleadings get completed, because when applications get listed for the first time, always an opportunity is given to the other side to file a reply. The other side, after filing a reply, a request is made by the applicant to file a rejoinder thereon. And in this pleading state itself, more than a year gets elapsed, but no settlement takes place. And after admission, immediately the settlement takes place. I'm talking about the application which are being made by the operational creditor, which are getting settled at a belated stage. These things can be avoided if there is an imposition of mandatory pre-mediation between the parties. Yes, so timeline, as we were discussing under the Mediation Act, that it shall be completed within a period of 120 days from the date fixed for the first appearance before the mediator. There is an extended timeliness which is provided, that is there in subsection 2 of 18. A period of mediation mentioned in subsection 1 may be extended for a period as agreed by the parties, but not exceeding 60 days. If this timeliness will not be considered discretionary, then in that circumstances, 160 plus 120 plus 60, 180 days. This 6 months, if tried upon, there are ample of possibilities that there will be a very less section 9 application at least. I will be dealing with some more important aspects, and that is pertaining to section 4. Now, when we see section 4, when we will be dealing with the CIRP, and when we will be talking about there has to be some mandatory pre-mediation, then irrespective of this fact, whether the operational creditor or the corporate debtor are having any mediation agreement or not, when we will be talking about a mandatory pre-mediation, then irrespective of the fact whether any terms of mediation is agreed upon by the parties or not, they have to have a mediation first. They have to opt for any mediation first. Only in case of failure of mediation, there will be a mandatory imposition of, or there will be a mandatory application which will be made before the adjudicating authority only once the mediation is tried and tested. So that will be a mandatory pre-mediation which we will be discussing for CIRP. But before that, when we see from the viewpoint of the Mediation Act, when it can be invoked. Section 4 of the Mediation Act 2023 talks about a mediation agreement shall be in writing, like an arbitration act, by or between the parties and anyone claiming through them to submit to mediation all or certain dispute which have arisen and which may have arisen between the parties. But Schedule 1 of this particular law, Schedule 1 of this particular act, it is stated that which are the dispute, or what are the nature of dispute which cannot be resolved through mediation. We will be going into the same. As far as this particular act is concerned, it is having a 65 section and 10 schedule. And when we see Schedule 1 talks about certain nature of dispute which cannot be resolved through mediation. Mediation agreement may be in form of mediation clause in a contract or in form of separate agreement, same like arbitration. Mediation agreement is in writing if it is contained in or recorded as any document signed by the parties. Exchange of communication or later, including through electronic forms. Any pleading, now this is important, any pleading in a suit or other proceeding in which existence of mediation agreement is alleged by one party and not denied by other, then also it will be referred as if there is a mediation which is one of the mandatory condition as agreed upon between the parties. A reference in any agreement containing a mediation clause shall constitute a mediation agreement. If agreement is in writing and the reference in such as to make the mediation clause as a part of the agreement. The parties may agree to submit to mediation any dispute arising between them under an agreement, whether entered prior to arising of dispute or subsequent thereto, meaning thereby, even after the dispute, the parties may agree to mediate and refer the case to the mediator to try it upon in case if there is a possibility of settlement through mediation. This is pre-mediation, and this is what I would like to put my views upon, that how this pre-mediation provision, how this pre-mediation provisions which are there in already under the Commercial Court Act, if placed in the CIRP, in regulation or in the IBC, how this is going to actually fulfill or serve the purpose of the IBC. There are certain challenges which we feel in the IBC, and that is the endless disputes. Resulting to those disputes, the focus of IP as an IRP or as an RP gets diverted. The timeliness are not being complied. Much of the time is being consumed in a litigation which is a inter-party dispute, like delay in submission of claim, non-submission of the claim, belated submission of the claim. These are the nature of dispute which does not assist the CIRP process at all. And how the Mediation Act can be helpful if there are certain provisions, if imposed, or certain provisions, if brought in the code itself, through which the timeliness can be curtailed. So would be dealing with the pre-litigation mediation as far as the Mediation Act is concerned. And then we will be discussing later on that how this pre-litigation mediation can also be a part and parcel of the code or the regulation, subject to other provisions of the Act. So subject to other provisions of the Act, recently we have studied that there has to be an agreement. But when you will see the pre-litigation mediation, it talks about where any mediation agreement exists or not. So when Act itself makes it mandatory that first the party should try and test whether the disputes can be resolved through mediations or not. So in that circumstances, it does not make any difference whether any agreement exists between the parties or not. The parties, before filing any suit or proceeding of civil or commercial nature in any court, may voluntarily and with mutual consent take step to settle the dispute by pre-litigation mediation in accordance with the provision of the act. Now think upon it. If there is a mandatory condition on an operational creditor that first, before moving an application under section 9 or before issuing any notice under section 8, they first of all opt for a pre-litigation mediation. I believe this. There will be a reduction in the number of applications which are being made under section 12. I do have a firm belief that 12A applications are nothing, but this is a settlement which arise out of the fear of admission of CIRP. But suppose if the settlement takes place in such a manner that pre-litigation mediation, a mandatory pre-litigation mediation, then most of the section 9 application will not even come before the adjudicating authority, and it will be resolved much before the application stage. So there is a question from one of the participant. In the alternate, the CD may raise dispute which at section 8 notice may be termed as a pre-existing dispute. See, I can say one thing. The CD raise a dispute. See, any dispute which are in existence. First of all, the dispute which are in existence prior to the delivery of demand notice are considered as a pre-existing dispute. First of all, you serve notice. Section 8 notice can be served upon. We will be dealing with in detail. But yes, in order to consider any dispute as a pre-existing dispute, first of all, the dispute has to be in existence before the service or before the delivery of demand notice. Meaning thereby, how the amendment is going to take place or how it can be brought in within the purview of the IBC, that is, yes. So basically, the pre-mediation can be initiated thereafter, so that one cannot take the advantage, and we will be taking care of that whatever may be the discussions or deliberation which are taking place in the process of mediation, that cannot be used as an evidence. That is also a part and parcel of our discussion within the Mediation Act itself. We will be taking care of the same, but that doesn't mean that if some disputes are being or some dialogues are being exchanged during the mediation process, that will consider as a pre-existing dispute. Absolutely not. So first of all, and even if disputes are in existence, the efforts will be made by the mediator to get it resolved before the news gets become a public. Because once application is made before the adjudicating authority, nothing stays in silent. Once matter get listed before the adjudicating authority, if a company is a blue chip company, everything comes on the media itself. So what I believe is, whatever may be the discussion or deliberation or whatever may be the exchange of thoughts or discussion which has taken place during the course of mediation, that can never be considered as a part and parcel through which the other side can take the advantage of the evidence. Subject to the other provisions of the Act, where any mediation agreement exists or not, the parties, before filing any suit or proceeding of civil or commercial nature in any court, may voluntarily and with a mutual consent take steps to settle the dispute by pre-litigation mediation in accordance with the provision of the Act. So suppose if this thing become a part of the IBC, once it become a part of the IBC, I do have a belief that you can actually able to comply with the other timeliness. The timeliness which is there under section 7 or section 9 or section 10. That is, within 14 days, adjudicating authority will either admit or reject the application. provided that the pre-litigation mediation in the matter of commercial dispute of specified value shall be undertaken in accordance with the provision of 12A of the Commercial Court Act 2015. So the same thing may be brought in under the IBC also. Yes, so it is provided that unless otherwise agreed upon by the parties, a mediator is registered with the council, that is a mediation council of India, which is also defined under this act, empaneled by court annexed mediation center. And there can be a possibility of the tribunal mediation cell or the tribunal mediation, NCLT mediation center, in which all the IPs, as if they are registered with the adjudicating authority, with mediation cell, the mediator will get the empanelment. Empaneled by the authority constituted under the legal service authorities like Lok Adalats, empaneled by the mediation service provider recognized under this act. So in this act, the hierarchy is of this nature. First of all, there is a Mediation Council of India, under which there will be a mediation service provider. They will be recognized by the Mediation Council of India. So Mediation Council, then mediation service provider, and thereafter the mediation institution, which will impart training or educate the mediators. For conducting pre-litigation mediation, a party may request any person designated for this purpose by High Court or authority constituted under the legal service authority, as the case may be. But see, when you see Motor Vehicle Act 1988, something can be derived out of it. In the Motor Vehicle Act 1988, when an application for compensation arising out of an accident is made before the claim tribunal, if the settlement is provided under 149 of that act is not arrived between the parties, then claim tribunal shall refer the parties for mediation through mediator or mediation service provider. And where the parties arrive at a settlement agreement, it shall be placed before the claim tribunal for consideration. And suppose if the party does not reach to a settlement agreement, a non-settlement report prepared by the mediator shall be forwarded to the claim tribunal, which has referred the matter for mediation. So basically, much of the time which are otherwise engaged in a court-driven dispute can be resolved. A mediation under this act shall not be conducted for resolution of any dispute or matter contained in the first schedule, as we have already discussed. This particular code do have 10 schedule, and when first schedule to this Mediation Act 2023 can be referred, it is provided that which are the nature of dispute which are not RB or which cannot be resolved through the means of mediation under this Mediation Act. This is also very important that nothing contained herein shall prevent any court, if deemed appropriate, from referring any dispute relating to compoundable offense, including matrimonial offense, which are compoundable and pending before the parties. Further, that outcome of such mediation shall not deem to be a judgment or a decree of the court. So this is how it can, you can say it can distinguish itself from the Arbitration and Conciliation Act. Outcome of such mediation shall not deem to be a judgment or a decree of the court and shall be further considered by the court in accordance with the law for the time in force. This is also very important. If the central government thinks it fit and is satisfied that it is necessary or expedient to do it, it may by notification amend the first schedule, which talks about the nature of non-mediation or which are the nature of dispute which cannot be resolved through mediation. This is something which I feel that the tribunal should be empowered as far as Section 7 of the Mediation Act 2023 is concerned. Notwithstanding the non-settlement of dispute under 1 of Section 5, a court or tribunal may at any stage of proceeding refer the parties to undertake mediation. I've seen nowadays the companies are accepting the fund from the private equity or from private equity players. Lot many SSAs are being, you can say, the companies are being a party to the shareholders agreement or share purchase agreement. And in all such agreement, there is always a reference to the clause of alternative dispute resolution. For example, non-redemption of compulsory convertible debentures, non-redemption of compulsory convertible preference share. Debenture per se is a debt. Preference shares are not debt. Basically, they are the share capital. but there is an obligation which are attached with those securities which are issued in the nature of compulsory convertible preference share or compulsory redeemable preference share. And section 55 of the Companies Act 2013 mandates company to redeem preference share within 20 years. Now suppose if company fails to redeem the same, I've seen many of the applications which are being referred before the NCLT, and the preference shareholders are approaching the adjudicating authority as if they are the financial creditors. And many of the applications I've seen which are being rejected also. Now, I don't understand why section 442 of the Companies Act cannot be invoked, or why this matter cannot be referred for mediation. Under section 442 Act, the regional director do have this power to empanel any person as a mediator, and mediation can be referred in such nature of disputes. Because see, ultimate aim, if a CCPS holder is claiming itself as a financial creditor and moving an application under section 7 of the IBC, the intent can never be a resolution. Insolvency and bankruptcy code do have one issue with it. The intent and the purpose of the application are totally different. Act has come up with its own object, whereas the tribunals are burdened with the applications which are being made with not that object which are there in the code. So there is a big difference between the objective of the code and the objective with which the applications are being made. And just in order to actually identify that the application is made for revival of the corporate debtor, there is a mandatory requirement which should be inserted in the insolvency and bankruptcy code, which talks about pre-litigation mediation, which is there in section 5, what we have seen, pre-litigation mediation, especially with the operational creditor. Because after that 24th of March 2020, when threshold limit has been increased to 1 CR, the objective was very clear that it is for the sake of resolution of the insolvent corporate debtor. And suppose if that fails, the corporate debtor will be dragged for the liquidation. But now again, day in, day out, we are referring to the judgment wherein the principal and interest club together, the operational creditor reaching to a threshold limit of 1 CR and moving an application. If the intent is actually the resolution, then in that circumstances, why not pre-mediation should be tried and tested? I'm referring to section 7 at this moment, wherein the power of the court or tribunal to refer parties to the mediation. And I must say one thing, that this should be encouraged during CIRP also. This should be encouraged in CIRP also, wherein the NCLT should also allow the corporate debtor to permit a mediation with its stakeholder. Basically, by doing so, I must say that there is a huge and ample of possibilities that even though the COC gets constituted, there is still a possibility of amicable settlement, and there is still a possibility that through this amicable settlement, the corporate debtor will be back on its feet. So section 7 of the Mediation Act, which talks about notwithstanding the non-settlement of dispute, even though it is tried and tested and mediator has submitted its non-settlement report, but the court and tribunal at any stage of the proceeding may refer the party to undertake mediation. If the court or tribunal refer the party to undertake mediation, it may pass suitable interim order to protect the interest of the party if deemed appropriate. The party shall not be under any obligation to come to a settlement in mediation. So this is very clear that there is no obligation on the part of the mediator that he need to bring out a settlement among the parties, and neither the parties are under any obligation that they have to abide by the mediation process in a manner that this should settled only through mediation. Suppose if the mediation could not be reached, then always there is a scope of litigation. I will not be referring, anyways, it can be checked that unless otherwise agreed upon by the parties, the person of any nationality can be a mediator. But yes, we will be see gradually the rules in this particular act, mediation act, which will be mandatory, talking about empanelment or registration of the mediator with Mediation Council of India or mediation service provider. The party shall be free to agree upon the name of mediator and the procedure for their appointment. So their appointment will be either the party will be deciding the same, or party will be approaching the mediation service provider, and mediation service provider will be appointing a mediator out of the empaneled mediators. If the party do not reach to any agreement on a matter referred to in subsection 2. So suppose if they are not coming to a consensus with regards to appointment of arbitrator, then parties seeking initiation of mediation shall make an application to mediation service provider for appointment of mediator. So either the party need to reach to some consensus. If party do not reach, then whosoever may be the party seeking initiation of mediation shall make an application to mediation service provider for the appointment of mediator. Upon receiving the application, the mediation service provider shall within 7 days shall appoint a mediator as agreed by the parties. In case if the parties are unable to reach an agreement with regards to appointment of mediator, or mediator agreed by them refuse to act as a mediator, then mediator from panel maintained by it with his consent will act as a mediator. So anyways, this is something which is not so relatable at this moment for CIRP, but the only purpose of going through this section is that how we may incorporate the benefit of this provisions in the IBC. The mediation service provider shall, while appointing any person from the panel of mediator, consider his suitability and preference of parties. So this is always subject to the parties' consent and subject to the availability and consent of the mediator also. Same provisions, conflict of interest, that person cannot be continue as a mediator, so I am not going through it. Termination of mandate of mediator, suppose if there is a conflict of interest which is later on found, or suppose if he withdraw his consent, then there is a termination of the mandate of mediator. Replacement is always possible, because when the parties have decided that who is going to be the person mediating their dispute, then there is always a scope available with the parties to replace it also. Territorial jurisdiction. So ultimately here it is provided that the territorial jurisdiction will be the place where the mediation takes place. And the mediation is going to take place at a place which is the jurisdiction. Court or tribunal jurisdiction will be the place where the mediation will take place. And suppose if that mediation will take place online, then also the jurisdiction will be considered the jurisdiction in which the court or tribunal falls in whatsoever act the dispute relates. So we will be taking care of the same, that every mediation under this act shall be undertaken within the territorial jurisdiction of the court or tribunal of the competent jurisdiction. Like in IBC, we do have a jurisdiction of the corporate debtor. So suppose if the supplier belongs to Mumbai, so in that case, even if mediation is going to take place, it is going to take place in Mumbai, because the tribunal, the NCLT Mumbai bench, will be having a jurisdiction to adjudicate the case thereafter, suppose if the mediation fails. Provided that on a mutual consent of the parties, the mediation may be conducted at any place outside the territorial jurisdiction of the court or tribunal. But it is provided in the explanation. It is clarified that where the party agree to conduct mediation at any other place outside the jurisdiction, that is a territorial jurisdiction, or even online, for the purpose of enforcement, challenge, which we are going to see, and registration of mediation settlement agreement, the same shall deem to have undertaken within the territorial jurisdiction of the court or tribunal of competent jurisdiction. Commencement of mediation. See, I would again like to emphasize upon that we are going through the Mediation Act, a recently enacted act. The only purpose is to actually brainstorm that how the provisions can be helpful if the mediation can be invoked in CIRP stage, pre-CIRP or a post-CIRP stage. And still the scope is there that mediation can be made mandatory in the Insolvency and Bankruptcy Code, especially a pre-initiation of CIRP. So in case, suppose if it is going to be brought in, unfortunately, there will be a less of litigation, but fortunately, there will be a ample of scope which will be there with the practitioner to act as a mediator. As far as Section 14 of the Mediation Act is concerned, the mediation proceedings with respect to a particular dispute shall deem to have commenced. A. So Section 14 Clause A talks about where there is an existing agreement between the parties to settle the dispute through mediation. The date on which party receive notice from the party initiating mediation to refer such dispute to mediation. So basically, when I'm going to receive the notice from the other side, and this is only going to happen when there is an agreement which is subsisting between us. So in case of an existing agreement between the parties to settle the dispute through mediation, the date on which the parties receive the notice from the party initiating the mediation to refer dispute to mediation, that will be the date. And in other cases are the cases when there is absence of an agreement, where the parties have agreed to appoint a mediator of their choice for mediation and settlement of dispute between them on the date the mediator provide his consent. So if both the parties have decided to opt for mediation, then in that case, when the mediator will be appointed and when consent of the mediator is received, this is provided.
Sir, I have a question. I'm Jay
Yes, sir.
Gopal. May I disturb you for a few seconds by
Please,
asking
sir.
a question?
Please, sir. Please, sir.
Sir, actually, I don't know whether I need to be corrected. See, in the internet, when we enter into an international contract or even domestic contract, we always insert a clause, whether it's purchase or services, an arbitration clause. Now, does it mean that we need to include this mediation clause also in the agreement?
Absolutely, yes, sir. When we see the enactment of the code, this enactment of the code has also impacted all those statutes where the reference of arbitration and conciliation is there. We see MSME. In MSME, the council always first try and test whether the disputes between a buyer and seller can be possibly resolved through conciliation or not. If fails, then matter will be referred for arbitration. In everywhere, the mediation word is inserted. Because see, the proceedings will run as per the relevant act. Up till now in India, there was no designated act for the mediation. But now when you will be mentioning the mediation, you need to be very specific that this mediation will run in accordance with the requirement of the Mediation Act 2023. So there will be a mandatory requirement. I'm reaching to that particular provision. This one. This is Section 2 of the Mediation Act, which talks about the act shall apply where the mediation is conducted in India. This act shall only apply where the mediation is conducted in India. And all or both the parties habitually reside in or are incorporated in or having their place of business in India. One of the preconditions. The mediation agreement provides that any dispute shall be resolved in accordance with the provision of this act. So mediation agreement, the concern question from your side. There has to be a mentioning. Mediation agreements provides that a dispute shall be resolved in accordance with the provision of this act. Now again, coming to your point, there is an international mediation. We will be dealing with that also. And where one of the parties to dispute is the government. So now there is a point which is confusing us, wherein one side it is stated that act shall apply where mediation is conducted in India. And on the one side, the clause 3 talks about there is an international mediation. So what is international mediation? It is also provided. This is clause G. Which talks about means a mediation undertaken under this act relates to a commercial dispute arising out of legal relationship, contractual or otherwise, under any law for the time being in force in India.
Okay. Okay.
This is mandatory requirement. See, if it is an international mediation, of course, one of the party must be a party residing out of India or having its place of business out of India.
Out of India. Okay.
But if the nature of dispute is pertaining to any law which is for the time being in force in India,
Okay.
then mediation can be made or mediation process will take place in accordance with the requirement of this Mediation Act 2020.
Okay. Okay.
Meaning
Thank you for
thereby, yes,
clarifying. Very interesting.
reference to the mediation is necessary if any of the party wants to invoke mediation prior to even arbitration.
Okay.
Otherwise, the arbitration will prevail.
Okay. Thank you so much.
Yes, sir. So basically, we were on the commencement of mediation part, wherein section 14 was being taken care of. Mediation proceeding with respect to a particular dispute shall deem to have commenced where there is an existing agreement between the parties to settle the dispute through mediation. The date on which a party or the party received notice from other party initiating the mediation to refer the dispute to the mediation. So that will be the date of commencement. In other cases, where the parties have agreed, so they have amicably and they have mutually decided to appoint a person as a mediator of their choice for mediation and settlement of their disputes between them, as on the date of when the mediator will give his consent for the appointment. Where one of the parties apply to a mediation service provider for settlement of dispute through mediation, then date of appointment of mediator by the mediation center, mediation service provider. But it is provided that a mediation process shall be conducted in a manner as may be specified. So rules are still not before us. The mediator shall assist the parties in an independent, neutral, impartial manner in their attempt to reach an amicable settlement. Mediator shall at all times be guided by the principle of objectivity and fairness and protect the voluntariness, confidentiality, self-determination of the parties and standard for professional. So this is one of the best thing I feel, confidentiality. Because when we talk about the insolvency and bankruptcy code, this is the only thing which is missing. A dispute between one operational creditor and a corporate debtor becomes so much public. Once application get admitted, the only dispute between, or only one dispute which was in existence between a CD and OC or a CD and FC, and that dispute is of a very similar, very small nature, and that is pertaining to non-payment of debt. That dispute, which otherwise was possible to resolve through a mediation or by the means of an arbitration or by the means of negotiation or conciliation, gets so much public that once applications get admitted, the IRP invites claim from all the claimants. And there is nothing remain confidential. So I believe that the mediation actually revives the repo or protect the repo of the corporate debtor from being publicly exposed as an insolvent entity. We will be dealing with the CIRP in detail, but yes, this act will take some time. The reason is it is novel to all of us. The mediator shall at all times, so anyways, we have studied this. Mediation process may include the mediator taking such measure as may be considered appropriate, taking into account the circumstances of the case, including meeting with the parties or participants, jointly or separately, as frequently as deemed fit by mediator, both in order to convene the mediation and during mediation for the orderly and timely conduct of the process. Role of mediator, this is what we have seen. Role of mediator in other proceedings, yes. So once I have been appointed as a mediator, there is a limitation on me. And that limitation states that if I was the mediator, then I shall not act as an arbitrator or a representative or a counsel of a party in any arbitral or judicial proceedings in respect of a dispute that is the subject matter of mediation proceedings. Tomorrow, this mediator cannot be a counsel. Mediator cannot be a representative. The mediator who was acting as a mediator, suppose if there is no settlement report which has been placed before the court or tribunal, that yes, the party initially made an attempt to reach to a consensus, but mediation fails. So now the same mediator cannot act as a representative, or the mediator cannot act as a counsel in any arbitral or judicial proceeding in respect of a dispute that is subject matter of the mediation proceedings. One more important thing, that mediator shall not be presented by the parties as a witness in any arbitral or judicial proceeding. So that is a kind of code of conduct, or that is a kind of limitation, or that is a kind of sensitivityness in this mediation act. Timeliness for completion, as we have seen, that this mandatory timeliness is far better than that 1 year or 2 year or 3 years ongoing proceedings pre-initiation of CIR. I have seen number of section 12A application. I have represented number of 12A application both before constitution of COC and after constitution of COC. But we feel that the only beneficiary at the end is the councils. Only beneficiary is the council, and we can say the applicant. But ultimately, how things got resolved only through a mediator, informal mediator. I've seen in many of the cases wherein if I'm the counsel who represented OC and applications get admitted, by all the references, the CD or CD's auditor or CD's company secretary or CD's director try to approach the counsel of the operational or the financial creditor whose application was admitted. And ultimately, the same counsel plays the role of a intermediary between the OC and FC's or OC and FC's board. And through this means, or through this channel, the consent terms takes place, or the parties enter into a consent terms, and the same counsel files an application for withdrawal. So when this is possible after admission, it is always possible before the initiation of CIR. I'm not talking about the CIRP at this moment, but just I'm touching upon. Time limit, we have seen 120 plus extended timeliness of 60 days, that is 180 days, the same what we have in CIRP also, but pre-CIRP, much of the time gets consumed. Section 19 of the Mediation Act, which talks about a mediation settlement agreement. So suppose if the mediation takes place, a mediation settlement agreement enter upon between the parties. A mediation settlement agreement includes an agreement in writing between the some or all the parties resulting from mediation, settling some or all the dispute. And this is one of the finest point I feel. It's not mandatory that all your disputes get resolved, but some of the dispute can at least be resolved. A mediation settlement agreement, that means when OC is claiming that I want my money back with interest, in that circumstances, always there is a possibility that you may ended up settling the terms with the CD and you may at least come out of your principal amount. A mediation settlement agreement includes an agreement. So this is nothing but basically the report card of your mediation process. Absolutely, yes, sir. I agree to this, Anil sir, and there where I'm going to place my viewpoint on the CIR. It may not be accepted by many of you, but what my thought process, that how mediation can turn the paper or can turn the table or can turn the picture, and basically how the purpose of the IBC can be achieved. That is what we are going to discuss immediately thereafter. Right now, we are dealing with the Mediation Act, and probably we will be completing the same within the next 20 minutes. And thereafter, within a break of 10 minutes thereafter, we will be taking care of that how this is going to be imposed or how this can be inserted in the IBC. 19. So mediation settlement agreement includes an agreement in writing between some or all the parties resulting from mediation, settling some or all the disputes between such parties and authenticated by the mediator. This is not arbitral award, not binding, no evidence, no CPC will be applicable in this. provided that the terms of mediated settlement agreement may extend beyond the dispute referred to the mediation. So terms of mediated settlement agreement may extend beyond the dispute referred to the mediation. A mediated settlement agreement which is void under the Indian Contract Act shall not deem to be lawful settlement agreement within the meaning. Where a mediated settlement agreement is reached between the parties with regards to all or some of their disputes, the same shall be reduced to in writing and signed by the parties. But before parties sign the same, it is going to be signed by the mediator. A mediated settlement agreement signed in case of institutional mediation. So where the mediator was appointed by the mediation centers, when the mediation settlement is an outcome of the mediator appointed by the mediation service provider, then it is referred as a institutional mediation, like we have institutional arbitration, Singapore arbitration, right? So in case of institutional mediation, the same shall be submitted to the mediator, who shall, after authenticating the same, forward it with a covering letter signed by him to the mediation service provider and also provide copies to the parties. In all the other cases, the same shall be submitted to the mediator, who shall, after authenticating the mediated settlement agreement, provide a copy to all the parties. The party may at any time during the mediation process makes an agreement with respect to any of the dispute which is the subject matter of mediation. Any mediated settlement agreement under this section include a settlement agreement resulting from online mediation. Registration not so relevant to discuss. Non-settlement report. So this is quite reverse to the outcome of settlement or non-settlement depends upon. So suppose in case if there is no amicable settlement which has taken place between the parties. So in case if the settlement takes place, that is what we were reading, that mediated settlement agreement. But in case of non-settlement, there will be a report known as non-settlement report. The pious objective has been lost, but basically I will say that that piousness is totally missing from the stage of application itself, sir. Was the objective of your application is actually the resolution? That is also very important. And that's why the purpose of the code is not basically what we can foresee even. And that's why I will exchange my thought process on it just few more minutes, and we will be actually dealing with our core subject of the day, ADR and CIRP. Non-settlement report, important one to take care of, subject to the provision of section 26. So we will be dealing with 26 also, wherein when no agreement is arrived at between the parties within the time prescribed as provided under 18, that is 120 and 60 days, or where the mediator is of that view that no settlement is possible, then he shall, in case of institutional mediation, shall submit a non-settlement report to the mediation service provider. So in case if he was appointed by the mediation service provider, then he will be submitting the same to the mediation service provider, non-settlement report. In all the cases, he is going to prepare a non-settlement report and provide a signed copies to the parties, provided that a report referred to in the section shall not disclose the cause of non-settlement. This is one thing wherein the confidentiality is at its supreme level. In this report, he shall not disclose the cause of non-settlement or any other matter or thing referred to in their conduct during mediation. This level of confidentiality which is going to be there when the mediation process can be opted first. So even though the settlement fails, a non-settlement report will be submitted by the mediator to the institution if his appointment was taken place through mediation service provider. And in case if the appointment was mutually taken place with the consent of the parties, then non-settlement report will be signed by him and it will be forwarded. Provide a signed copies to the parties. This is one of the important aspect of the mediation which we are going to deal with, section 22. And this is what I feel that why its insertion will be useful in CIRP matters. subject to the other provision of this act. A mediator, mediation service provider, the participants in the mediation shall keep confidential all the following matter relating to the mediation proceedings. You are not exposed before the word that you are insolvent or you are the one who initiated insolvency application. The things will remain under cover. You can still maintain your relationship. You can still make an attempt, give one more chance to the defaulter debtor to try to amicably settle the case. Because I feel that in CIRP, the dispute is very much of a dispute with regards to an amount. And this is also a known fact, a very hard fact, that OC's applications, even if admitted, OC is only the loser at the end. Which operational creditor has gained out of his case, even after the admission, his priority under 53 shall remain with that level only. And that is where the objective of the code actually comes into the mind of the operational creditor. He's always get advised by the advocates or practicing professionals to move such application, but OC is the biggest casualty. Absolutely, sir. And that's why when we will be dealing much into the mediation in IBC, we will be happily coming out of this fact that this mediation can actually bring a miracles, or alternative dispute resolution mechanism can bring a miracles to the objective of the code, and the purpose of the OC will be actually get resolved, because no OC or no FC is actually willing. Because I've seen many of my own clients who, after entering into a settlement, in spite of all their willingness, have failed to develop the same business relationship with the corporate actor. That's because of that wrong driven dispute, a litigation. This, in the process of this litigation driven process of insolvency and bankruptcy code, section 9 or section 7, even if settlement take place, their relationship, their business relationship, their confidentiality, all get exposed. Section 22. Subject to the other provisions of this act, a mediator, so who are supposed to maintain the confidentiality, is there under section 22. It's not only the role of the mediator to keep the things confidential, but also the role of mediation service provider, that body from where the appointment has taken place. The parties, so not only the parties to the dispute, but all the participants, their advisors, their counsels, their auditors, their consultants, shall keep confidential all the following matter relating to the mediation proceedings, namely, इस पूरी प्रोसेस में, इस mediation की पूरी प्रोसेस में काफी acknowledgements हुए होंगे. They must have acknowledged many things. There may be some of their opinion which should have been expressed. Multiple suggestions, promises, proposals, apologies, admissions made during this mediation process. But this cannot be used as an evidence tomorrow. Acceptance of that, willingness, accept proposals made or exchanged in the mediation. But this can never be a useful tool tomorrow if this party enters into a litigation. Documents prepared solely for the conduct of mediation. None of those documents are going to be a public document. Any other mediation communication. This is very important now. No audio or video recording of the mediation proceeding shall be made or maintained by the participants, including mediator and mediation service provider, whether conducted in person or online, to ensure the confidentiality of the conduct of mediation proceedings. Here, when proceedings takes place before the NCLT or NCLAT, no requirement to keep the things confidential, because everything is accessible to the stakeholder at large. So basically what I can say, even though the purpose of the Insolvency and Bankruptcy Code is to maximize the value of the asset of the corporate debtor, but how the asset of the corporate debtor or the value of the corporate debtor will be even maintained, leave maximization, when things are before the public at large that this company is going through a severe financial difficulty. Moving on, no party to the mediation shall in any proceedings before the court or tribunal, including arbitration tribunal, rely on or introduced as an evidence any information or communication set forth herein above, including any information in electronic form or verbal communication, and the court or tribunal, including arbitral tribunal, shall not take cognizance of such information or evidence. Very important. And this is how we can recognize the benefit of mediation in any litigation. The provision of this section shall not prevent mediator from complying or disclosing a general information concerning matter that have been subject matter of mediation for research, reporting, or training purpose, if the information does not expressly or indirectly identifying a person or participant. So for research and training purpose, it can be used, otherwise not. Again, a very important one, section 23. No mediator or participant in the mediation, including experts and advisors, engaged for the purpose of mediation and person involved in the administration of the mediation shall at any time be permitted, compelled to disclose to court or tribunal or in any adjudicatory proceeding by whatsoever description any communication in mediation or to state the content or conditions of any document. So basically the things will be the confidential even if your mediation fails. Even if your mediation fails, a non-settlement report, what we have seen, a non-settlement report will not mention the grounds of non-settlement. And this can never be used as an evidence. Termination of mediation. So we are going to be on a concluding side of this particular law. And one important thing, on 9th itself, on 9th October, many of these sections, I'm talking about just yesterday, many of the sections of this Mediation Act 2023 have come into force. So this is now on its track, and probably the possible impact will be there on all the act, including Companies Act, wherein the reference of any dispute can be referred to the mediator. Termination of mediation. Mediation proceeding under this act shall be deemed to terminate on the date of signing and authentication of mediation settlement agreement. What we see in CIRP. CIRP comes to an end in case if the resolution plan is approved by the adjudicating authority. In a very same manner, the mediation proceedings shall deem to be terminated on the date of signing and authentication of mediation settlement report or an agreement. On the date of written declaration of the mediator after consultation with the parties to the effect that further efforts to a mediation are no longer justified. So when the parties are of that opinion that no mediation will further be prolonged, and even if prolonged, no settlement are possibly going to take place. So on the date of written declaration of the mediator after consultation with the parties to the effect that the further efforts at mediation are no longer justified, or when the time is expired, what we have seen in section 18, 120, an extended time of 60 days. Cost of mediation, this is something which can be identified that it is going to be incurred. It is going to be incurred by the parties. All the cost of mediation, including fees of mediator and charges of the mediation service provider, shall be borne equally by the parties. Limitation. This is one of the important aspects which probably, if not after certain more discussion, this is going to be a question before the participants that what will be or what is the case if the timeliness to move an application under 7 or 9 get expired. Here you will get that benefit. Here you will get that benefit that notwithstanding anything contained in Limitation Act or any other law for the time in force, in computing the period of limitation fixed for any proceedings. I said in computing the period of limitation fixed for any proceedings, relating to the dispute in respect of which mediation has been taken under this act. The period from the commencement of mediation under section 14 up to the submission of report under 21, that is a mediation settlement agreement, or termination of mediation until 24 shall be excluded. So whatever time it was spent from the date of appointment of mediator, that was a commencement, notwithstanding anything contained in the Limitation Act or in any other law for the time in force, in computing the period of limitation fixed for any proceedings relating to the dispute in respect of which the mediation has been undertaken, the period from the commencement of mediation under section 14 and up to the submission of report under 21, that is settlement report, or termination of mediation under 24, the timeline shall be expired. So all the concern that what in case if the time will be expired are no longer subsist. This is the
Could you
establishment of.
share this limitation provision through an example?
Yes, it can be. See, we referred section 14, which talks about when it will be considered as if the mediation is commenced. So suppose if there is a dispute between both of us and you served a notice upon me to initiate the mediation through appointment of a mediator. So where there is an existing agreement between both of us to settle the dispute through mediation, the date on which the party or the party receive the notice from the party initiating mediation, that will be the date considered as a commencement of mediation. So from that day itself. In other cases, so suppose if there is no agreement which is existing between us and we both have mutually decided to appoint Mr. X as a mediator in our case. So we both, the parties, have agreed to appoint Mr. A as a mediator of our choice for settlement of dispute. Then in that case, when mediator will provide his consent, that will be the date on which the commencement will be considered, or the mediation shall be considered as if it is commenced. And last but not least, when the parties to the mediation, or when both the parties, we both of us, approach a mediation service provider for the appointment of a mediator. So from the date when mediator is appointed by the mediation service provider. Why I'm discussing section 14 is section 14 is the date, a trigger date from which the limitation will stop. And this is what we have seen when it will be considered as if it will be extended, or when it will be considered, or what are the timelines which shall be excluded. So submission of report under 21. What is the report? That is a settlement report. So if the dispute is amicably settled between the parties, then mediator will sign the report and will send it to the parties. So that day will be the date when the trigger, when the timeliness will be excluded. The timeliness from the commencement of mediation till the date of completion of mediation, that will be excluded. So tomorrow, if some part of our dispute got settled through mediation, some part of the dispute was settled through mediation, but still there is a dispute for which a mediator itself has submitted a non-settlement report. So for that, we are always having a flexibility to approach a court or tribunal. So when we will be approaching a court or tribunal, whatever time was consumed from the commencement of mediation till this date, submission of report under 21 or termination of mediation under 24, that time will be excluded. In the IBC, as we have seen, the residual article of Limitation Act 1963, Article 137, which talks about 3 years from the date of default. In that circumstances, the date of default will remain same, but whatever time was consumed in the mediation from the commencement of mediation till submission of settlement report or till submission of non-settlement report, that time will not be considered, and it will be minus from the period of date of default. If tomorrow we will be referring an application to the NCLT under 7 or 9 or 10. So that period will be excluded, which is provided under section 29 of the Mediation Act 2023, that notwithstanding anything contained in Limitation Act or in any other law for the time in force, so this act will supersede. In computing the period of limitation fixed for any proceeding relating to the disputes in respect of which the mediation has been undertaken under this act, the period, and this is very important, the mediation has been undertaken under this act. So if the mediation is undertaken under this act, the period from which the commencement of mediation up to the submission of report under 21 or termination of mediation under 24, that timeliness will be deducted. It will be excluded.
Most of the cases, this limitation period is excluded in case of any litigation is going on. So I think there is nothing, more specific is written herein.
Yes, what is provided is, suppose if the litigation is going on now, this is not so litigation, but again, this mediation should not be an informal mediation, subject to condition if this mediation has been initiated under this act. See, you cannot exclude every litigation. So matter which was tried before the SARFASI, you cannot exclude that period. If arbitration application was moved before the High Court and arbitration application got rejected and no arbitrator was appointed, in no case that period will be excluded. Suppose if you remain silent thereafter. So there are multiple challenges, but here what is provided is, if the mediation is initiated under this act, date of appointment till the date of submission of report by the mediator or non-settlement report by the mediator, the period will be clearly excluded. Nothing new, but one can say that yes, expressly provided that if the invoke, and what I wanted to say is, in CIRP, when we are going to club this particular law with the CIRP, if the question will arise that whatever time was vested in the mediation and because of which the limitation period was expired, so basically at that time section 29 will sounds to be so relevant, otherwise not so new thing.
Thank you, sir.
Yes. Now, the things which I would like to refer is Schedule 1 to this particular code, to this particular act, which talks about which cannot be mediated under this act. So which are the nature of dispute which cannot be mediated? It is provided in this particular Schedule 1, which says dispute which by virtue of any law for the timing in force may not be submitted for mediation. So that's why my emphasis is on IBC should promote this mediation before CIRP, post CIRP. Otherwise, if it is totally barred, then in that case, there will be no scope through which the benefit of this mediation act can be extended to the court. Dispute relating to the claim against the minors, that is, the person with intellectual disabilities or the persons with a mental illness or person of unsound mind. So this is provided that any dispute pertaining to the same or with a person of unsound mind or the person who is mentally ill, these are not referred for a mediation, or dispute involving prosecution for criminal offense. Meaning thereby whatever may be the outcome of your buffet transaction, this cannot be mediated. Extraordinate credit transaction or preferential transaction or a fraudulent transaction, this cannot be mediated. This is also very important that a complaints or a proceeding initiated before any statutory authority, meaning thereby even after the approval of the resolution plan, if the Ministry of Corporate Affairs have initiated investigation or some investigation was going on against the erstwhile promoter, even though the same promoter has got the approved resolution plan is in hands, but now this is not a thing which can be resolved through the mediation. Complaint or proceeding initiated before the statutory authority or body in relation to a registration, discipline, again, a practicing chartered accountant or practicing cost accountant or a company secretary or an advocate, wherein the proceedings are pending before the Bar Council of India or the proceedings are pending before the disciplinary committee of ICAI or ICSI, these are not the nature which can be resolved through mediation. Dispute which have effect on the rights of third parties, very important part, and where I'm going to discuss the critical aspect of the mediation in CIRP. When it is in personam, it is possible. Mediation can be a very strong tool till the applications get admitted, because up till that stage, the stakeholder interests are missing. Up till that stage, no other stakeholder interest is connected. But once applications get admitted, even if you will promote mediation, but you cannot end upon mediating the dispute with all the other stakeholders. So this is one of the very important aspect to be taken care of, and that is what my view is, that why the mediation should be promoted in pre-CIRP stage, or why there has to be a pre-litigation mediation. Because when the disputes which have an effect on the rights of third party who are not a party to the mediation proceeding, except only in case of matrimonial dispute where the interest of child is involved, which is not relatable to the CIRP. So basically, this is what provided any dispute relating to levy, collection, penalties, or offense in relation to a direct, indirect tax or refund enacted by state legislature. These are not the disputes which can be resolved through mediation. Proceeding before the SEBI or SAT cannot be. Land acquisition or determination of compensation under the land acquisition law. So this is what provided under this Mediation Act. But now my entire focus, and as we studied that, how it has impacted every other act. So we are referring to those acts where the preference or where the reference of mediation is already provided under this act. Industrial Dispute Act, Brahmaputra Board, Family Courts, Legal Services Authorities, Finance Act, Industrial Relation. But even otherwise, in the Companies Act also, there is a reference to the mediation. In RERA also, there is a reference to the mediation. So there will be an impact on those acts also. In this, I was mentioning about this MSME. I was mentioning about this Micro and Small Enterprise Facilitation Council, MSMED Act 2006, wherein the reference of mediation is provided. You can find this under section 18.4 of the 18.4 of the MSMED Act, where it is provided now that where the reference to Micro Small Enterprise Facilitation Council, that is MSEFC, notwithstanding anything contained in any other law for the time in force, any party to a dispute may, with regards to any amount due under 17, make reference to MSEFC. On receipt of reference under subsection 1, MSEFC shall either conduct mediation, which was absent earlier. MSEFC shall either conduct mediation itself or refer the matter to any mediation service provided under Mediation Act. The conduct of mediation under this section shall be as per the provisions of the Mediation Act. So now mediation has got his place in the MSMED Act. Where the mediation initiated under 3 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternative dispute resolution. So that is what my point was. Because of the enactment of the Mediation Act 2023, the reference of the same is provided manywhere. See this Companies Act. In the Companies Act, it is there in section 442. Under section 442, it is provided in, there is chapter number 29, which talks about reference to mediation. Any of the parties to a proceeding before the central government. I can directly touch upon CIRP right now. Debenture holders moving an application under section 7 for financial credit. Depositors moving an application under section 7 as a financial creditor. Why they should not be dragged for the mediation if there is a possible outcome which may derive there? Because their grievance is very much limited to non-redemption of debenture on non-repayment of the mature deposit there. Any of the parties to a proceedings before central government, here the central government refers to the regional director. There are 7 RD offices under the Ministry of Corporate Affairs. Any of the parties to a proceedings before the central government or even tribunal, that is NCLT or appellate tribunal, may at any time apply to central government tribunal or appellate tribunal, as the case may be, in such form along with such fees, if any, as may be prescribed for referring the matter pertaining to proceedings for mediation in the central government tribunal or appellate tribunal, as the case may be, shall refer the matter to mediation to be conducted under the Mediation Act. A fantastic provision which is not being used by the litigants. Fantastic provisions. The only purpose of calling it fantastic is because the word used is shall. Tribunal and appellate tribunal, as the case may be, in such form along with such fees, they can be referred. And after referring the matter pertaining to such proceedings for mediation, and central government and tribunal shall refer the matter to mediation to be conducted under the Mediation Act 2023, through which the possible resolution to dispute can be achieved. Nothing in this section shall prevent central government tribunal or appellate tribunal before which any proceeding is pending from referring any matter pertaining to such proceedings suo moto. So this is not only the case when the parties on achieving on reaching to a consensus, they can move an application to the RD or NCLT or NCLAT. RD, NCLT, and NCLAT can suo moto also refer the matter to the mediation which is going to be conducted under the mediation as per the Mediation Act 2023. The mediator or the mediation service provider shall file the mediation settlement agreement arrived between the parties with the RD or tribunal or NCLAT. The RD or tribunal or NCLAT shall pass an order or judgment making the mediation settlement agreement as a part thereof. Fees of the mediator again as may be prescribed. So this is just the introduction to what the Mediation Act 2013-23 is all about, and how the benefit of mediation can be derived by the code, that is Insolvency and Bankruptcy Code. I'm having so many things to discuss upon. Many of the things are workable. Many of the things as going to be discussed are not practical in nature. So there are going to be the practical constraint which we are going to see when we will be dealing with a mediation or alternative dispute resolution mechanism in CIRP, pre-CIRP and post-CIRP. We will be taking up all the aspects from which we can gain some benefit of the Mediation Act 2023 enactment in the Insolvency and Bankruptcy Code or IBBI insolvency resolution process for corporate persons regulation, and how if these things get inserted benefited litigants or disputing party. That is what we are going to oversee in the next phase of discussion. Before that, if something is required to be discussed upon at this moment, we will discuss the same. Else, we can initiate the discussion pertaining to the IBC or pertaining to the CIRP after a break of 10 minutes. If there are certain things to deliberate upon, discuss upon, we can take it up right away. If we can take it up after the discussion of the CIRP proceedings, or how ADR mechanism can be useful tool during CIRP on pre or post CIRP stage, we can discuss that first, and then we'll take up the question. We will be taking up the discussion further immediately at 4 o'clock, and we will be dealing with how the Mediation Act is going to be one of the tool in IBC proceedings and how the purpose of the code actually can be achieved. I'm just requesting for a break of 10 minutes. May we initiate? We can initiate, and now we can touch upon the provisions of the insolvency and bankruptcy code, and how the mediation can be a tool which can be inserted, or how the pre-litigation mediation can actually assist the participants of the CIRP to reach to the objective of the CIRP. Here I would like to start upon with section 9 or section 8 application. Here I can say section 311 debt and 312 dispute. That is the only nature of dispute which subsists between the operational and the corporate debtor. So basically, there is no dispute per se other than the default with regards to payment of an operational debt. What I believe is, see, whatever I'm going to discuss henceforth are my viewpoint that how ADR system, or how the ADR is going to be a tool or the mechanism through which the objective of the CIRP can be achieved. As far as my understanding is concerned, there has to be a pre-litigation, a mandatory pre-litigation mediation for every operational creditor who either is a micro or a small enterprise, and there has to be an obligation on them to first reach to a consensus or not. When I say mandatory, so there is an obligatory on the part of the operational creditor to first invoke section 1718 of the MSMED Act. What I believe is, this probably will end up their dispute much before the time when they will be thinking to approach the NCLT for initiating section 9 application. So I believe that for every micro and small enterprises, there has to be a mandatory pre-litigation mediation. The objective will be achieved out of it. One more thing I would like to say: when an application which is moved by the operational creditor, and when such application is clubbed with the principal amount plus interest amount, when such application is made, and the application is made or is prepared in such a manner that just in order to trigger section 4, they have clubbed the provision of both interest and principal. Basically, when the principal and interest are being clubbed, or when interest is being clubbed with the principal amount by the operational creditor, the intent starts from the very same day itself when they have calculated the amount of interest together with the amount, a principal amount. I must say, when the nature of application per se is of this nature, or when the nature of application is of this nature, wherein the principal along with the interest is touching upon 1 CR, mandatory for the parties to first invoke the pre-litigation mediation. I must say, it will safeguard and it will actually protect a very vital or very much experience, very much expensive time of the adjudicating authorities. Because I've seen many such applications wherein the high part of the litigation or a very time consuming part of the litigation is basically to adjudicate upon whether such application is maintainable or not. I have my opinion on the same. When operational creditor is a service provider and previously been a related party to the corporate debtor, and just abusing their position erstwhile, they move an application under section 9. I must say mandatory pre-litigation mediation. Mandatory pre-litigation mediation for such nature of application, wherein a service provider is moving an application, was a related party at one moment, and abusing his power or abusing the internal information or database available with him just because of a kind of relation which he was having with a corporate debtor. One more thing I've seen, when a claimant or the practicing professional or the consultant or an advisor moves an application under section 9, should not be allowed before they invoke first a pre-litigation mediation, a mandatory pre-litigation mediation. They should not be allowed. In case after service of demand notice, suppose if the demand notice is served by an OC, and where any, rather I'm not talking about a pre-existing dispute, because if there is a case of pre-existing dispute, Mobilox is very clear that irrespective of your case, it is going to be in favor of the CD only. But even otherwise, if upon service of demand notice, if I'm getting any reply within a time frame of 10 days, and if any dispute is being raised, first of all, there has to be a pre-litigation mediation in such nature of application wherein the issue will get resolved or not. So before it reaches to the NCLT, it gets distilled at the very first stage. In this such nature of application also, the emphasis should be given to the pre-litigation mediation when already CD is in CIR. I'm touching upon one of the aspect after my experience with Manpasand beverages. I've seen so many promoters striving hard to get back on its feet. Don't have too much liquidity, but having asset to come out of the CIR. What happened actually when CIRB gets initiated? When CIRB gets initiated, basically the IRP and RP always remain on the front face. The power of the board gets suspended, not the board gets suspended. If there will be a possibilities that through mediation, if they can settle with the other disputes, if their long-term intent is to have a settlement with the applicant and with COC thereafter, I'm talking about 12A, I'm talking about regulation 38. If the CD will be permitted and if the mediation will be one of the prerequisite, or the mediation will be allowed for a promoter for settling their disputes, some other disputes, even though the CIRP is admitted, even though the application is admitted and I'm in CIRP, because section 11 debars me to move a section 10 application. I want revival, I want resolution, I genuinely want to amicably settle the disputes. But I've seen, you must have seen that there are multiple applications being made against a distress entity. There are multiple applications been made against the distress entity. So when one applications get admitted, there is no meaning of moving any another application for the same purpose, which has now been infructuous. There is no purpose of moving another application against the same CD because the CD already been admitted in CIR. In such circumstances, pre-mediation is going to be one of the tool, or to promote mediation in between a corporate debtor and its other stakeholder will assist corporate debtor to amicably resolve the dispute. It can safeguard the corporate debtor from further application, and there is a high chances that the settlement under 12A may take place. So basically what I feel is under section 8 or under section 9, there has to be a pre-mediation in certain circumstances, the circumstances which I have referred. When OC moved an application for a default amounting to 1 CR, the threshold is reached with principal and interest in such category of the application. Or when the OC is a service provider or previously been associated as a related party to the CD. In case of the terms of contract, yes, this is one of the important aspects which I was missing. If there is already a term or there is a contract which is in existence, which mandatory talks about a mediation, which talks about alternative dispute resolution mechanism, then they first be allowed to trigger that particular way of their settlement before they reach to the NCLT for initiating CIR. Because the ultimate intent is to get their operational debt back or to get the repayment of the financial debt. So when already some agreement is subsisting between both OC and CD, then there should be that mediation clause or that alternative dispute resolution clause should be triggered first before they try and test CIR. In the case when the CD is responding to the demand notice, not even raising pre-existing dispute, but raising dispute, in such circumstances also, there should be a pre-litigation mediation among them, which should take place first. And then the application under section 9 be entertained. Because in such circumstances, more than 50% of the cases will be resolved before even approaching NCLT, when already CD is in CIRP. And that's why I would like to say section 11. Section 11 does not allow such CD to invoke section 10. They cannot move an application even though they want a resolution. In such circumstances, having a provision of mediation with other stakeholder in absence of the intervention of the IRP and RP will assist CD to avoid the further litigation. That is what my thought process is. Under section 7 application, when section 7 application is made, there is always an element of public. In case if application is being made by a bank or public financial institution, there is a straightaway interest of public is involved when application is been made by the bank or financial institution. Keeping them aside, what I believe is if section 7 application is being made by a financial creditor, which is not a bank or which is not a financial institution, in that circumstances, if it is not a bank, if it is not a financial institution, if it is not public financial institution or NBFC, in such circumstances, there has to be a mandatory pre-litigation mediation. If I, being a financial creditor moving an application, there has to be a pre-litigation mediation. And one cannot straight away knock the door of NCLT for initiating CIRP. That is what my thought process is. If OTS proposal, I have to take up this just a second. Yes, settlement with OC would not establish the sustainability of the CD since IBC is not a recovery tool, but a resolution mechanism. Rather, CD should pass through a sustainable test. So that is what my point is. I've seen many of the application which is being made by the operational creditor on a solvent entity actually. This is also very important that the inability of payment of a debt and non-payment of debt are different things. Inability indicates insolvency. Insolvency requires resolution. Resolution requires CIR. But in case of a financial stable entity, if it's not making payment of a debt, then always, if the emphasis will be given to the pre-litigation mediation, probably the purpose will be achieved. Yes, I was talking about many of the bankers' application I've seen where OTS proposal is under consideration. I don't know why, but when the OTS proposal is pending before their committee of bank under consideration, OTS proposal is under consideration before the committee of bank, meaning thereby some sort of agreement or disagreements are already in discussion. In such circumstances, the bank should not be allowed, even though it is a bank, they should not be allowed to invoke Section 7 application. Because that is adding on unnecessary litigation. And this unnecessary litigation is ending up with the settlement only. Because ultimately, what bank is going to think at the end of the day is the settlement, the OTS proposal, even if not accepted, the bank will insist the borrower to come up with some enhanced proposal, and later on such enhanced proposal gets added. So I do have a firm belief that if the settlement or any one-time settlement proposal is under consideration before the committee of the bank, in such circumstances, Section 7 application should not be permitted. If the financial creditor who was moving an application under Section 7 was a related party or is a related party, because there is no as such, the court does not debar a financial creditor being a related party to initiate CIRP. They can. But what my strong suggestion, what my strong opinion, what my strong understanding, what my strong perspective is that if a financial creditor is a related party, there has to be a mandatory pre-litigation mediation. Again, if there is an agreement subsisting between both the both the corporate debtor and a financial creditor, and there is a reference to any mediation agreement or alternative dispute resolution mechanism, then again there is, like what we discussed in Section 9, here also there has to be a mandatory pre-litigation mediation. Yes, that is what I was discussing. If the financial creditor is a debenture holder, if a financial creditors are the depositors, if the financial creditors are such class of financial creditor like home buyers, because there is always a provision of Section 32(9) under RERA, which talks about the same thing, mediation. Similarly, we have seen Section 442 of the Companies Act 2013, read with chapter number 28, which we have seen that there is a provision of the mediation and conciliation rule. There is a company's mediation and conciliation rule. So in case, why the debenture holders are feeling aggrieved, or why the depositors are feeling aggrieved, the only purpose of being aggrieved or feeling aggrieved is the company, the corporate debtor has failed to redeem debenture or has failed to repay the mature deposit. This is the limited grievance. For that, there is a provision under the Companies Act which says that in case of non-repayment of deposit, they can go before the NCLT under the Companies Act for the limited purpose of recovery. Or under Section 71 of the Companies Act 2013, it is provided that if company fails to redeem debenture, then debenture trustee can very well move before the NCLT. Then the question is, why before the NCLT under IBC? When your specific act, when your principal act is having a remedy inside that act itself, then approaching, knocking the door under Section 7 touching a doorbell of section 7 is something which is not bringing an application, or which is not considered as an application with an aim of an objective of IBC. Yes, very important thing which I would like to have with you. There is a provision, or there is a provision which talks about a pre-existing dispute in case of an operational debt. But there's no reference of any pre-existing dispute in case of financial debt. But disputes are there. In case of non-disbursement in a timely manner, at the time when the fund was actually required, the financial creditor has not disbursed the amount when it was required, and CD was dragged in CIR. In such cases, whereas a subsisting of dispute is there, but when debarring this, I will say that in such circumstances, if we think from the perspective of IP, absolutely it will go against. But yes, these are the cases where majority of the litigations are finally being settled, where the settlements are being taken place. That is the thought process. So I was talking about a pre-existing dispute in case of an operational debt application. Tomorrow it is not going to be maintainable, but there is always a case of disputes in financial debt also. And IBC is not meant for, and adjudicating authorities are not meant for adjudicating such matters. Adjudications are before the civil court. And that's why these are not the nature of the application for which IBC can be invoked. Section 10 application. Now coming to the very important aspect. I just wanted to listen from your side. If Section 10 applications Section 10, now let us discuss the Section 10, and I will be happy to have your views. Section 10 application mandatorily require the consent from 3/4 of my partners if my company is, if my entity is the LLP. Otherwise, shareholders approval with a spatial resolution. Now we know that shareholders are having no place in CIRP. Shareholders are having no place in resolution plans. Shareholders are having no place in Section 53. Why shareholder back such a resolution for Section 10? You will find majority of the Section 10 application with a very suspicious eyes. 99%, I will say that 99% of Section 10 applications, 99% of Section 10 applications are being made by such entities where the directors and shareholders are one and same. I have never seen, if I would be a shareholder for which the CD's board of directors or the board of directors of the corporate applicant are approaching me for my consent for moving a Section 10 application, why should I give the consent? The intent of Section 10 application is the avoidance of proceedings, or when they don't want themselves to go into liquidation and they want that somebody, or let us move first. Go first is an exception. I just wanted to know the second company in similar panel of go first. While having, or while initiating discussion, I was of that view that the Section 10 example of Go Air is going to come my way. But I just wanted to know how many like Go Airs. How many companies like Go Airs? Invoking Section 8. Shareholders are backing the decision of the corporate applicant for moving Section 10. If you actually see the number of applications been rejected, such applications are under Section 10. That is what my point is, sir. That is what my point is. Section 10 applications basically are being made in order to avoid proceedings. They make their balance sheet empty first and they move Section 10 application. Where is the purpose of the IBC being achieved? Where is the purpose of IBC being achieved? The first and the foremost thing which has to be seen is to whom the corporate debtor has committed default in making payment and who these parties are. This need to be reviewed first. And these are not basically, see, I will be talking both critical aspect also. The moment 10A will be coming my way. But my point is very clear that why pre-litigation mediation will actually scan the important application which are important for the economy as a whole, for the stakeholder as a whole. I truly believe, I firmly believe that majority of the Section 10 applications are very much purposeful. And such application should be referred or should be dealt under Section 271 of the Companies Act, wherein the tribunal possesses power to pass liquidation for just and equitable ground. Just because they don't want to spend. Because in liquidation, once ordered by the NCLT, the liquidator remuneration is being paid by the company's resources. Here it is very clear that once the application under Section 10 will be admitted, the CD will be happily living. Absolutely, yes, sir. Absolutely, yes. I'm having a very critical understanding, or I'm having very critical views for 10A, the insertion of 10A. The 10A was inserted with a specific objective. 10A was inserted with a very specific objective. I will be having my views on it. Why there is a blanket exemption or why there is a blanket immunity? I have seen many of the application wherein I myself is the representative of the applicant. Default relates to 10A period. That is 24th of March 2022, 21, 25th March. Default relates to 10A period, but the CD was very punctual and very much regular in making payment for entire suspension period. And default has taken place just in the month of December 2020. This is something which is, they should not get, especially for MSME, I do believe it. The 10A was basically meant for a specific purpose. Was for many, but why? There are certain things which I would like to share, that why Section 10A is also applicable in case of Section 10 application. I'm talking after having this answer. Yes, it was brought in for MSME. So you want MSME to further wait if Section 10 application, if MSME intends to move an application under Section 10 for a default during suspension period, why Section 10 application should not be allowed when all the stakeholders of the corporate debtor itself have decided? The corporate applicant, after getting necessary approval from the shareholder, is moving Section 10 application. I just wanted, I've seen the cases. 10A should not be 10A should not be completely, or 10A should not immune such corporate debtor or defaulter completely. There has to be some industry-wise classification to be provided, because I've seen the IT companies were booming at that time. The equal weightage to be given to their balance sheets. Equal weightage should be given to their balance sheet. If compared from the financial year 1920, it was more healthier. Year 2021 were even more healthier. 21-22, it was upscaling. Then why such immunity? Why such immunity? I have certain thoughts. 10A should not be blank. There should not be any blanket immunity. That is what my thought process is. Industry-wise classification should be made mandatory. One important aspect, default of 1 crore or above, please mark my words, default of 1 crore or above during 10-A period, suspension period, the CD has committed a default of 1 crore or above, there has to be a mandatory pre-mediation. If the corporate debtor hesitates to mediate the case, meaning thereby the intent is just to take the benefit of 10-A. Mark my words again, default of 1 crore or above during suspension period. The financial statements are healthy in comparison to the financial year 1920. 2021, they outperformed. Default of 1 CR subsisting during 25th March 2021. Company has performed better than previous year. Mandatory pre-mediation. See, I am not allowed to move an application under section 7, under section 10, under section 7 or 9. All right. But there has to be a pre-mediation. And in such circumstances, if the other party hesitates to mediate the case, the intent will be all before the adjudicating authority, and adjudicating authority in such circumstances, अगर ऐसा होने लगता है, तो there is a full possibilities जो आज की तारीख में नहीं हो रहा है. When you see section 9 subsection 5, within 14 days from the date of application, the application can be admitted. Section 7 subsection 4, same thing. 14 days from the request when the application is made, and same with section 10 subsection 4, adjudicating authority generally has to decide the case within 14 days. It will be very easy for the adjudicating authority, because here the proceedings prolong for months and years. That is what my thought process is. Also a mandatory mediation. The threshold limit of 1 CR is against OC and especially MSME, but today's section uniformal. Even if you wanted to move an application under section 7, it is mandatory upon section 7 financial applicant, a financial creditor applicant, wherein they have to justify that default is committed by the corporate debtor and default amounts to 1 CR or more. I just have one more views. Default continues. So there was a default committed by the corporate debtor during suspension period, and default even continue thereafter. There was a default during a suspension period, that is 25th March 22, 25th March 21, though it was below 1 CR, and default continued thereafter. In suspension period, the corporate debtor has committed a default, and the corporate debtor continues making default even after a suspension period. But since the amount of default outside that suspension period is less than 1 CR, why there should not be a pre-litigation mediation, and why the OC or FC should not be allowed to move an application to initiate CIRP? This is my question. I do have firm belief that if there will be a pre-litigation mediation, if made compulsory, like we have in 12A of the Commercial Court Act 2015, you will be having a leaser application under section 12A read with regulation 30A. You will find 8 out of 10 applications are being made immediately after the admission of CIR. You find this. I don't have states with me, but that is what my limited observation to the CIRP proceedings. The moments applications get admitted, the CD is settling with the operational creditor, the CD is settling with the financial creditor, and just because of the fear of the public announcement. So the public announcement, which is one of the mandatory requirement to be made within 3 days of the commencement of the CIRP, just within the span of 3 days, 12 applications are being finalized. If you will make mediation one of the mandatory requirement, that is a pre-litigation mediation, you will find a certain reduction in section 12A application, which is being made under section 12A of the IBC read with regulation 30A. The important aspect, what I was referring again and again, NCLT should promote corporate debtor to mediate the disputes even after the admission of application is finalized, or even after the initiation of CIRP of the corporate debtor, you will actually able to identify the difference between the promoters. You will find the difference between the category of the promoter. Such a mediation will always encourage, ended up with, and yes, there is also some bar also. Because see, if the application is admitted against the corporate debtor, that means CIRP is running, IRP or RP is on the driver's seat. But if the CD will be encouraged to mediate the certain nature of disputes, what will happen tomorrow? The same CD will be in a capacity to put, to have a settlement with the applicant. And once the settlement is made possible with the applicant, he will be having all the privilege to settle with COC also. But I must say that this is just a thought process, and wherein unless and until it will be made mandatory in certain areas of CIRP, I know it's a bit challenging once applications get admitted, because as I said, if it is right in personam, this is something which is doable, because there is the interest of only the corporate debtor and the applicant which are basically impacted. But once the applications get admitted, basically it is in RAM, and there are multiple stakeholders whose right and interest are going to be affected. So that is what I believe, that practical difficulties are yes there, but yes, to make it compulsory like Commercial Court Act 2015, many of the application will be distilled, many of the application will be disposed of at a very preliminary stage, and adjudicating authorities are going to adjudicate only upon those applications where the resolution of the corporate debtor or insolvency resolution process is mandatorily required. Section 13, once applications get admitted, the NCLT, that is adjudicating authority, direct IRP, appoints IRP or RP, appoints IRP, and IRP under section 13 is mandatorily required to give a public announcement. Whereas if there is a provision of the pre-litigation mediation, you will be safeguarded your company from being publicly exposed as a insolvent entity. See, it was just a beginning wherein the default, or it was just a beginning was taken place, or beginning was basically between a corporate debtor and one applicant. The dispute begin from a default which the corporate debtor has made in making payment of an operational or a financial debt. But just because of they fail to pre-mediate, or they fail to enter into a mediation, pre-litigation mediation, what happened is tomorrow that application got admitted. And once applications get admitted, it was publicly recognized that this entity is undergoing CIR. And what we have seen in the CCD case. What we have seen in the CCD is something which can easily give us a smell that how a pre-litigation mediation would have been helpful to the promoter of the CCD, because ultimately they ended up with a settlement only. One more thing, the moratorium wherein say there is a stay in proceedings, but this proceeding should exclude mediations. The proceeding should exclude mediation, then purpose of the code will further be achieved. So section 14 moratorium shall not be extended in case of mediation. One more thing. I've seen, see, there is no immunity as such to the personal guarantor under section 14. This is what we have seen, that even though the resolution plan gets approved by the adjudicating authority, even if the resolution plan gets approved by the adjudicating authority, the applications under section 95 of the Insolvency and Bankruptcy Code are being made for initiating insolvencies of the personal guarantors. The personal guarantors, if they will be promoted to invoke mediation with the same financial creditor or the financial creditor of the corporate debtor, there are the possibilities that you may get the top seat tomorrow. If you will be submitting the resolution plan, you will be in the good books of those COC members. So basically, in order to avoid section 95 proceedings, there is a kind of flexibility, or there is a kind of a mandatory pre-mediation option to be given to the personal guarantor to the corporate debtor, so that the proceedings of section 95, whose constitutional validity is under consideration before the Supreme Court, can be avoided. There has to be a provision of NCLT mediation cell, because I've seen corporate debtor once admitted in CIRP, much of the litigation are pertaining to the non-admission of claims. Claims can be entertained by the IRP or the RP for 14 days, which is permissible under the law, within 14 days from the commencement of CIRP. Even thereafter, the regulation 12.2, which is recently amended on 18th of September 2023, wherein subregulation 2 is omitted, and it is stated that up to 90 days, IRP, up to 90 days, the RP is going to entertain the claim, but no claim should be entertained. It's not about the regulation, but it is the objective of the regulation, which I'm highlighting. After 90 days, basically, this is the stage where already the request for resolution plan is being made before the prospective RAs. Before the prospective RAs, the request for resolution plan is being made. Right? This is not the stage when the role is of the RP to oversee or to verify the claim. That time is gone. That time is gone when the claims were invited. So claim was invited at the time when public announcement was made. There was a time frame of 14 days which was provided under the code. Under the regulation, it is provided that belatedly also it can be submitted before the RP, and RP may verify, and RP may alter the list of admitted claims. But this is a doable task for an RP for a specific number of days. But the problem is RP is being involved and being occupied in all these applications which are being made under section 60 subsection 5, wherein the applications are being made by the claimant, and the claimants are before the adjudicating authority feeling aggrieved because the IRP or the RP has not admitted the claim. For such nature of dispute, there has to be a mandatory mediation cell in the NCLT, or NCLT refer, or NCLT used to refer such kind of matters before the mediation cell. Because what happened actually, this is the never-ending litigation. Because if I'm the RA, if I am having a no knowledge, because I am the RA, I'm preparing the resolution plan as per the details or the information provided to me by the RP. I will be considering all the figures into consideration which are there in the information memorandum. Tomorrow, even after the exchange of the information to me, if the claim will keep on adjudicating by the NCLT, then I will be ended up doing nothing. I have decided to place a resolution plan of 50 CR, but tomorrow, just because the claims been kept on entertaining by the NCLT, and NCLT was adjudicating the belated claim and directing RP to consider the claim, the interest of the resolution applicant is in jeopardy. So there is a firm belief that large number of the disputes are pertaining to non-admission of the claims and delay in submission of the claim. And basically, this is an interpersonal dispute which actually take much of the RP's time during CIRP. And these are majority of the cases because of which the CIRP gets extended. There has to be a mandatory reference which will be given to the mediation cell of the NCLT, who are going to mediate upon and communicate the same to the RP, and RP further communicate the same to the adjudicating authority, that these are the matter mediated upon and this is the outcome. Mandatory to resolve the claim related issue through mediation cell after the furnishing of IM to PRA, amended regulation 12.2. As majority of the CIRP got delayed due to the due to pendency of such application of delayed claim. And basically, this pendency of litigation is not adding value to CIR. It is diminishing the value of the corporate debtor. So there has to be a kind of mediation cell. I don't know how much of you are going to agree upon, but many of 19.2 application may also be settled if mediation can be emphasized upon. I don't know how many of you are going to agree upon this, but this is what my belief is. Because as I said, the power of the board of directors are suspended and not the board per se. Tomorrow, if the same promoter of the corporate debtors are willing to submit a resolution plan, then they will be all in a position to cooperate the IRP or the RP. In such case, the mediation probably may be a helpful tool. Basically, section 20, which talks about to keep the corporate debtor as a going concern. I've seen many of the IRPs and RP remain busy in collating the claims, inviting the resolution plan, submission of the plan, getting the plan approved from COC and from the adjudicating authority. But having a mediation as one of the mandatory tool, there is the purpose of keeping the corporate debtor as a going concern can be achieved. Section 20 of the Insolvency and Bankruptcy Code. Dispute resolution between assenting and dissenting financial creditors. I have one critical thing to say about section 30 subsection 5. Section 30 subsection 5, which I believe require utmost clarity. If I'm the resolution applicant, if I'm the resolution applicant and also having a seat in COC, I'm the resolution applicant also having a seat in the COC because I'm a financial creditor also. I'm holding 30% of the voting share. Where is the commercial wisdom? I'm not talking about mediation at this moment. I'm not talking about alternative dispute resolution in this moment. I'm just talking about section 30 subsection 5, which is very much arbitrary in nature. Unlike in the Companies Act, which talks about interested director will not be counted as a quorum, will not be entitled to vote, where the concept of interested person is missing in section 30 subsection 5. A section 30 subsection 5 entitles or give a resolution applicant to even vote for its own plan if such resolution applicant is a financial creditor. And because of this section 30 subsection 5, many of the CIRP are being converted into liquidation. I'm the financial creditor having a seat in COC with 30% voting share. I'm also the resolution applicant. Why should I be allowed to vote? Because if I will be allowed to vote, my vote will always go in favor of my plan and my vote will always go against the plan proposed by other resolution applicant. Where is the commercial wisdom of me over my own plan? I will always see my plan with my biased eyes. In such circumstances, if I will be not allowed to participate in COC during evaluation of or during the approval of my resolution plan, and my resolution plan will only be voted upon the disinterested participants of the COC, then probably the purpose of the commercial wisdom will be achieved, otherwise not. Because in this given situation wherein I'm having a seat in the COC, having 30% voting share, meaning thereby having 35%, rather 35% voting shares I will be having all the powers to block any other resolution applicant's plan just because of I have the privilege of being a financial creditor and a member of the COC. 100% my vote will go in my favor as far as my plan is concerned, and 100% my vote will go against the resolution plan proposed by other RA. This nature of disputes are never-ending dispute, and I've seen that leading to such disputes, the corporate debtor, the CIRP, first of all gets delayed. Many litigation takes place challenging the constitution of COC per se. And that is the only reason the objective of the CIRP per se is not being realized. whenever there is a question of determination of the amount of claim, first of all, as we have seen in regulation of this IBC, we have seen section 6A regulation 6A of the IBBI insolvency resolution process for a corporate person. It should made mandatory for the IRP to intimate all the creditor which are there in the books. IRP should be have a, first of all, it is there already there in regulation 6A, mandatory intimation to all the creditor. But yes, there is a leniency provided in the same regulation. Once public announcement is made, it is deemed communication to all the stakeholders. But when I'm having the books of accounts in my hands, and when I know these are the creditors of the corporate debtor, why I should not be, or why I should not intimate the initiation of CIRP to all those creditors? Because once I will be communicating the initiation of CIRP to all the creditor, tomorrow I will be having all the reason for not considering claims if the claims are being submitted belatedly. And henceforth, if the provision mandates them to refer such kind of claim to mediation cell of NCLT, much of my time will be safeguarded. Much of my productive time will be safeguarded, because these disputes are basically not value added to CIRP, very much against the interest of the resolution applicant. I can say at this moment, how much possible, how much it is not possible, that is the time which will convey us. But I must say, I will back the government of India in case if they will impose a mandatory pre-litigation mediation, especially for an OC, because they, in any case, their application, even if admitted, they will not end up getting anything. And if there is if ultimately such applications are going to be ended up with settlement only, then why this settlement should not be promoted much prior to their application. So I can say that this Mediation Act 2023 will bring out some changes in the IBC. That is for sure. I'm not talking about in pure sense with regards to arbitration, but yes, as far as mediation, which is quite informal in nature, wherein a mediator can bring some sort of settlement. And if this settlement is possible, then why 12A and why not pre-litigation mediation, like we have in commercial court? I would like to rest my further discussion here itself, and will invite your views.
Sir, I'm Jay Gopal. May I
Good
say a point? You mentioned about, I think this section 30, subsection 5, about the related party, where the financial creditor is the resolution applicant, and which he has been given the voting power. I think that is very relevant. It's a very. I read this, but earlier this point didn't strike in my mind. But after reading the Income Tax Act and Companies Act, where the related party transactions are take different view, even IBC itself, they say related party where the preferential transactions matter all viewed in a different way. I think this lacks consistency. This lacks this particular.
Absolutely, because I have witnessed myself being a counsel of number of matters. I've
Yes.
seen a solid resolution plan, a very sustainable, a very viable resolution plan are being rejected.
Oh my
Because
God.
such resolution applicant, qua financial creditor,
Yes.
are blocking the other resolution applicant to put forth their plan. And even if their plans are being placed before the committee of creditor, such kind of financial creditor in the capacity of resolution applicant are blocking their plan.
So that means a
So
very unfair.
the concept which is there in SEBI or under the Companies Act, which talks about related party should not be the person who can intervene, is very relevant concept to be brought in this IBC.
Very true. Very brilliant point. I mean, when I read, I didn't understand. Now I really got it. How I missed, I'm really surprised. Great. Thank you.
See, Viniji, my submission is why entertain the delayed claims? Put all mechanism at first place, whether RP has to communicate with every creditor from the books of accounts, whatever needs to be done. Put a deadline. Mediation or no mediation or NCLT.
Absolutely.
It will delay.
Absolutely. I
Those who are,
fully
So-
second your opinion, sir. And that is what my
Yeah.
point is. If
These
when I
are-
have been appointed as an IRP, my
Yeah.
first role is I need to simply engage my intern, or I simply need to engage my assistant. He will simply write a one-pager intimation with a public announcement to all the creditors. The
Yeah.
moment I did my task, I will not be a person who is going to further entertain any claim after the preparation of IM.
except few rare exceptions, you know, otherwise they should not be intended. The IBPI on 18th September, the regulation, the changes they have made, they will further complicate the issue. Because now
Absolutely, sir.
RP is expected to file an application with NCLT for the delayed claims. RP, why RP should file the application? How it will
Absolutely. And how the interest of the CD or the RA is going to be positively impacted. This is nothing but this litigation is going to consume time for which none of the parties are going to be a beneficiary.
I'm,
Majority of such applicants are the OC.
you
And
know,
OC are
I'm
getting
surprised. IBPI has brought these changes to resolve the problem. It will further complicate the issue.
absolutely, sir.
Suppose RP does not, there are delayed claims. RP is not accepting the claim. They say it is rejected. RV with the RP, that operational creditor or financial creditor, the claimant, still has a right to approach NCLT. The
Absolutely.
NCLT will be flooded with petitions only.
Absolutely, sir.
So it will not reduce the number of petitions. Number two, my submission is that all non-material issues, why there should be petition under section 60 subsection 5 by anybody who can file. There should be some list of areas where the petition can be filed. For non-material issues, you refer to mediation.
Very
And
correct, sir.
it should not affect the resolution process.
Absolutely, yes, sir. Absolutely, yes.
Irrespective of the judgment by the mediator. You know,
Absolutely, yes, sir.
because non-material issue should not take over material issue.
Absolutely, yes, sir. Absolutely, yes.
That is why NCLT is entertaining every application from every stakeholder. If suppose there are 500 workers, 200 workers can file application.
I agree to you, sir.
One issue has already been filed. No other person should be allowed to file. I think
Very correct, sir.
you have given a very wide perspective. My only the other question, the point is that see, with due respect to our Indian promoters, by and large, insolvency process is happening because of the financial failure, not because of the business failure. In 80% of the cases, it is business failure is the only showcase. So why accept the application unless the promoters have come clean on PUFIP transactions? Whether it is
Absolutely.
application under section 7 or 9 or 10. Let
Very
them come clean. Let them come clean.
And that was my point was, sir, section 10 application, if you will see, which section 10 application gets a support from its shareholder. When you read section 10 and when you see the outcome of the CIRP, which shareholder is going to get what, but still the shareholders are backing section 10 application.
Because they are the owners, they are the promoters.
They
are
themselves are the owners.
So they are trying to evade the all diversion of funds, whatever wrongdoing they have done, they want to evade and save themselves from all legal actions which are going on.
Absolutely, yes, sir.
So there should be rather, Vinitji, there should be rather examination of existing cases which are going on.
Again,
When application under section 10 is filed, what are the cases going on? Let mediation decide. These are the grave economic criminal offense they have committed. In this case, the application cannot be admitted. Let the clearance come from mediation cell first.
Yes, sir.
Let it be referred to mediation cell. Especially application under section 10.
Absolutely, yes, sir.
The only thing is that unless we want solution, every law has pious objective, but we misinterpret, and IBC was a summary trial. IBC was not a full law.
Absolutely, sir.
It has become a litigation. It has become feast for the legal fraternity.
Feast for a legal fraternity.
They,
And more importantly, the adjudicating authorities are basically messed up with resolving the dispute or adjudicating the dispute, which is not basically per se the objective of the court.
because the people who are sitting in the adjudicating authority are having the same mindset. They are high court judges, or they feel the timeline, they don't, because Supreme Court initially said timelines are not recommended, are not mandatory for themselves. So they have got the freedom. That's all.
Correct.
Resolution plan is languishing in NCLT for years.
4 years.
How can you tell SRA to take over the company after 3 years? The whole situation has changed.
Absolutely, sir.
So I think, to my mind, the government of India is not serious about IBC, as it was serious before. You know, they were interested in resolution of some top 200 cases. Those cases are resolved. Now it has become any third grade law of the country.
But now those cases are basically the precedent wherein the SR Steel word mandatory for 330 days is omitted. So
Yeah.
basically, as such, there is no timeliness which is prescribed within which things need to be resolved.
So it has lost its sanity. It has become just any other law where you file a petition and you do not know when the judgment will come.
Absolutely, sir.
Like any other law, So with due respect, the mediation might help if it is strictly implemented. But implementation is a big challenge in our country. In a corrupt society, implementation becomes we can have good laws, we can have good intent, but where is the implementation? Who will implement? Implement any law properly, it will work.
Right, sir.
But you bring another law to implement the other law, repair the other law, and don't implement any law, nothing will happen. Things will be languishing in mediation also. What is happening in RERA? Did you hear the judgment of some Madhya Pradesh High Court, or which High Court? They say if the legal bench, the three-member bench, if they have not signed the judgment, if they have not heard the petition, those orders are void. Where the hell you were there for 5 years? There are n number of judgments which have been passed. Where will they go?
Absolutely, yes.
Why did you allow the functioning of the RERA tribunal without 3 members?
If its constitution itself is not valid.
And they were hearing the cases, they were passing the verdict, and the orders are signed by one person. Now, after 5 years, you say all orders are void. So what will happen, sir? What will happen? Where the home buyers will go, poor fellow,
Correct, sir.
Every builder will challenge the order. They will not honor the order. Anyway, thank you so much for giving a fresh perspective. Perspectives are good, but let the lawmakers and other people.
Thanks a lot, sir. Thank you very much.
Thank you so much.
Thanks a lot, sir.
Yeah.
Thank you so much, sir, for such
Thank you very much.
nice session.
It's pleasure on my part to be a part of this, you can say, a learned gathering or gathering between a learned professionals. Thank you very much, sir. Thank you,
Sir,
ICSI.
you will be to please share your PPTs.
Ma'am, I will be sharing the same, but it was basically the Mediation Act only. I will be sharing the same.
Okay, sir.
Thanks a lot.
Thank you.
Thank you.